Good afternoon. My name is Tim Callgreen, the Director of Civic Education at the Indiana Bar Foundation, and welcome to our 2021 We the People Spring Professional Development Workshop. And we're looking at teaching the executive branch today. This is going to be the culmination of our continuing professional development series on learning and teaching constitutional topics for this school year. And so our next professional development opportunity will be our Summer Institute, which I will talk about after both of the presentations. And so we're excited that we have so many teachers that are joining us this afternoon, taking your time to be a part of this. We hope that you find this useful to learn content and teaching strategies that you can bring to your classroom. As you've seen on our agenda, we have two presentations this afternoon. We're going to start with Dr. David Adler, and then we're going to turn over to Dr. Elizabeth Osborne for our second presentation. So I'm sure this isn't anyone's first Zoom meeting, but just a few best practices to say is keep your microphone muted, please, unless you're speaking. You may choose to keep your video off if that's your preference. If you happen to be watching in gallery view, you might want to choose to hide non-video participants so that blank boxes don't take up the valuable real estate on your screen. If you haven't done so, please rename yourself, having your full name, and you might want to add in the grade level that you're teaching, so we get that idea too. During the presentations, if you have any questions, go ahead and pop them into the chat box while you think of them. We're going to go ahead and queue those up and monitor the questions. And when we get to pausing points, we'll call on you to ask your question. Or if you'd rather, you can send the question directly to me and I can ask it on your behalf as well. So we've got our two presenters. And so, like I said, our first one, I want to introduce Dr. Adler first, and then we'll introduce Dr. Osborne as well right before her session. So let's start with this. Our first topic, the evolution of executive power. It's timely and relevant. We're only 80 some days into this new presidential administration. And so we're learning how President Biden is coming into his own leading his administration. But he is the 46th president in our history, so we've had a chance to see how previous presidents have handled presidential power while they're in office. Dr. Adler is going to be looking at how executive power has shaped, changed, and evolved over time. Dr. Adler is president of the Alturas Institute, a nonprofit organization based in Idaho, created to promote the Constitution, gender equality, and civic education. A recipient of teaching, writing, and civic awards, Dr. Adler has lectured nationally and internationally and published widely on the Constitution, presidential power, and the Bill of Rights. He's the author of 6 books, including most recently, The War, Power, and in the Age of Terrorism, as well as more than 100 scholarly articles in leading journals. Dr. Adler's writings have been quoted by the U.S. Supreme Court, lower federal courts, the U.S. Attorney General, White House counsel, legal advisors to the State Department, Republicans and Democrats in both houses of Congress, political science, historians, and law professors. He's consulted with members of Congress from both parties on a variety of issues, including impeachment, war power, and termination of treaties. Dr. Adler has presented many times for Indiana teachers, and we're pleased to have him return once again. So the Indiana Bar Foundation is pleased to introduce Dr. David Adler speaking on the evolution of executive power. Dr. Adler, floor is yours.
Well, good afternoon, Tim, and thanks very much for that nice introduction. It's great to be back with some of my favorite educators in the country. I love Indiana. I'm sorry we're not together, but Zoom is the new norm, and it's a great way to communicate and share ideas. Thanks to you and Joseph for the invitation. It's nice to share the podium today with Professor Osborne. In the time we have together, I would very much like to hear the questions from teachers. I learned a lot working with fellow educators down in the trenches. And so I'm here as a resource for anything you want to ask about with respect to presidential power. But let me start off by talking a little bit about what the framers of the Constitution had in mind when they invented the presidency and how it has evolved over 2 centuries plus. So for starters, we want to remember, of course, that the framers did in fact invent the office of the presidency. And that reflected their deeply felt concerns, given their experience under the Articles of Confederation, for the need for a full-time executive. Under the Articles of Confederation, as you recall, there was no full-time executive, and that very much undermined the efficiency of the young republic. And the framers very much regretted the fact that there was no executive to efficiently administer the laws or to carry out the policies passed by Congress. And so in the Constitutional Convention, in fact, on June 1, Edmund Randolph of Virginia introduced the idea of creating a presidency. There was a pause in the proceedings because this was a new creation and nobody knew what this would look like. Well, it began to take shape that day when, in fact, Governor Randolph, one of the leading politicians in the country, widely respected, in part because Virginia was a very powerful state at that point. And he introduced the concept of the presidency by saying that the president should essentially inherit the executive powers exercised by Congress under the Articles of Confederation. This made sense. Let's just have the executive exercise those executive powers. But it was not clear what constituted an executive power. So immediately, the question arose whether or not the president, for example, would possess the authority to go to war, which under the Articles of Confederation was granted to Congress. But does this mean the president would have the authority to go to war? There was, again, Madison tells us in his notes, a pause. Why? Because in England and in European countries, it was a common practice for the executive of that nation to have the authority that we would call the war power, the authority to take the nation into war. But the framers closely associated the war power with executive prerogative or the royal prerogative wielded by the King of England. And they did not want one person to have the awesome authority to take the nation into war. So what to do about that? Immediately, several framers said, well, writers on the law of nations, what today we would call international law, were in complete agreement that the war power is not an executive power, but in fact a legislative power. Therefore, it would not be proper to grant to the executive a power that is understood to be legislative in nature. And then that triggered a further conversation in which fears of executive war making surfaced. And the framers said, well, the Congress should have this power. Well, that was a stunning development because that meant that for the first time in the history of the world, the power to go to war was not going to be vested in the executive official leading a country, but in fact in Congress. And we'll come back and talk about this a little bit more. But that meant that the framers were quite prepared to tear up any existing models for executive authority. That is to say, they were breaking sharply and frankly pretty dramatically from the English model in which so much governmental authority was vested in the king. And the framers were going their own way. They were independent thinkers, and they began then to carve up the executive powers or what were considered to be some executive powers that would be granted to Congress and some possessed by the executive. In that long summer of 1787, several framers lamented that the most difficult chore they faced was to create and to establish the presidency, particularly engaging in difficult deliberations on what powers to grant to the president. It was particularly difficult because that was a generation that lived in strong fear of executive power. And that's understandable because, of course, they'd fought a war with England to free themselves of executive tyranny, and their deep and wide readings in history told them that executives across the centuries had often exploited the people, not for meritorious reasons, of course, but for the executive's own interests, personal, financial, political. And so they were very fearful of a strong executive. And so what occurred in the summer was what James Madison said, and that is that executive power will be confined and defined. We're going to confine executive power. We're going to place a limit, a ceiling, and then we're going to carefully define it so everybody knows which powers were granted to the executive. So as a starter for our conversation, and as I told Tim, well, we could talk about this for weeks on end, but as a starting point, we would look at the text of Article 2. Article 2, of course, is known as the executive article. That's the source of all the president's constitutional power. You will see that the president's powers, in comparison to those granted to Congress, are pretty few and far between. That is to say, the executive possesses lean powers, and that was, as I say, deliberate. The framers wanted to create a presidency that was sharply confined. And so you would see, for example, in the first sentence, the executive power of the United States shall be vested in a president. What did that signify? Well, we know, of course, that it meant that the president would be a single officer. There was a debate whether we should have a single or a plural presidency. The title, president, signifies the conclusion of a debate as to what we were going to call the chief executive. And there's the reference to the executive power shall be vested in a president. What's meant by executive power? This is a fascinating subject on which I've written and I enjoy talking about. But in our limited time, suffice it to say that the framers thought that the essential executive powers would be the authority to enforce law and the authority to appoint people to offices created by Congress. That's what the framers had in mind when they spoke of that term executive power. And by the way, the founding generation in the United States created that term executive power. They did it out of necessity because any prior discussions or writings about the executive in a nation always dealt with royal prerogative or executive prerogative. The King of England, of course, enjoyed sweeping authority, as John Locke explained, the authority to act in the absence of law, to meet an emergency, or even to violate a law in order to meet an emergency. But our framers did not want to vest such broad authority in the president. They didn't want to call the authority or the power granted to the president by the name prerogative, because that smacked of monarchy. And in fact, in that day and age, a great way to stab your political opponent with derision was to say he's an advocate of prerogative powers. That was a nasty, for better or worse, a four-letter word in a sense. Nobody wanted to be called an advocate of prerogative powers. And so the framers withheld from the president a broad prerogative power, or what we might call an emergency power. So if you continue through Article 2, you'll see that the president, as the public well knows, is the commander-in-chief of the Army and Navy when called into service. What does that mean? Presidents, of course, like to extol the virtues of a broad conception of the commander-in-chief clause and make all sorts of claims, including that it gives to the president the authority to go to war. It gives the president the authority to act in the name of national security or the common defense. It gives the president the broader authority to make and to conduct foreign policy. It does nothing of the sort. The framers had a very narrow view of the commander-in-chief clause, and that was to sharply limit the president's authority in response to either an invasion of the country or to conduct war once Congress had declared it or otherwise authorized it. And Alexander Hamilton makes these points very, very clearly in Federalist 69. As you ask your students perhaps to read some of the Federalist Papers, number 69 is the most important when it comes to foreign affairs and national security. And you'll find that the framers withheld the power to go to war from the president. The commander-in-chief had the authority to repel an invasion. When the nation was attacked, the framers believed there might not be time for Congress to assemble to decide how to respond. Therefore, in the face of such an emergency, they wanted the president to be able to repel the invasion. And if Congress declared war on another country or authorized military hostilities, the president would be expected to prosecute the war or to carry out the hostilities in the most efficient, successful way possible. So our students need to know that the authority to initiate hostilities or the authority to go to war is vested solely and exclusively in Congress, not the president. And they might be surprised to learn that, in fact, nobody in the convention ever argued for a presidential war-making power. It was a unanimous decision. There was one person on August 17th who thought that maybe the president should be given that war power, but on that day, the rest of the framers piled on, so to speak. And by the end of that discussion, he retreated and said, just as Congress alone has the authority to take the nation to war, so too does Congress have the authority to end war. So the discussion coming out of Philadelphia on the authority to go to war and the scope of the commander-in-chief clause was crystal clear. It has undergone considerable revision over the last 200 years. And that's primarily because, particularly beginning after the Cold War, members of both political parties and certainly presidents of both political parties have wanted to assert that the president should be able to act quickly and make the principal decisions on the question of going to war or using military force. Thus, Harry Truman was the first president to assert an executive war power when he took the United States into war in Korea. Ever since then, virtually every president has asserted the power to go to war, even though that assertion finds no basis in the text or the architecture of the Constitution. We live essentially in an era of presidential usurpation, a fancy word for theft, usurpation of the war power. And that continues, frankly, because members of Congress, for a variety of policy and political reasons, are not eager to stand up to a president. If the White House is controlled by a Republican, for example, then Republican Party members in Congress are not likely to challenge the assertion of the Republican president. They want to support their guy in the White House, and the same is true of Democrats. What we actually need is a restoration of a constitutional presidency that would require Congress to make that critical decision to go to war. Maybe there'll be questions about that. Also in Article 2, we find that the president shares the all-important treaty-making power with the Senate. This is important because all the way up to nearly the end of the convention, the power to make treaties, which the framers conceived of as the primary way in which the nation's foreign policy would be carried out, would be vested solely and exclusively in the Senate. It was James Madison who thought there ought to be a counterweight or a balance to the Senate's authority, and he was the one who introduced the motion, which was approved, to add the president. This means the treaty power is a shared power. It's worth noting that the president was added as an afterthought. I say that just so that we can have clarity that the framers expected that American foreign policy would be carried out in a shared way between the president and Congress, but that Congress would be the senior partner, the president, the junior partner. When we talk about how presidential power has evolved over 200 years, it's clear that presidents believe they ought to be not merely the senior partner, thus flipping the script, but they should have the sole and exclusive authority to make and to conduct American foreign policy. In fact, they resent it if Congress intrudes. Talk about flipping the Constitution on its head. It is in the area of foreign affairs where we see that in a more pronounced way than any other part of the Constitution. And again, our students could be asked to read Federalist 69 that speaks to the limits placed on the president's authority as commander-in-chief, and specifically Federalist number 75, in which Alexander Hamilton talks about the treaty-making power. So it's good. It's not only a good historical practice for our students to understand what the framers had in mind, but it's a good analytical way to demonstrate, I think, good critical thinking to say, this is what the framers wrote in the Constitution. Now we are essentially light years removed from the framers' perspective. And it's not just a changed perspective because, of course, the Constitution is the law of the land. So we could ask, how would the president justify ignoring or indeed violating constitutional provisions? And in fact, how do members of Congress justify ignoring their responsibilities in the area of foreign affairs, in war making and treaty making and so forth? Treaty making has largely been replaced by presidential resort to executive agreements. What's interesting about this is that this gives the president a vehicle to make a more American foreign policy by deciding which nations he'll have relations with, what the tenor and tone of those relations will be, what kind of agreements he might strike. And that operates almost to the exclusion of the Senate and its role in treaty making. Why doesn't the Senate more jealously guard its constitutional power in this area? Those are good, thought-provoking questions for our teachers. In addition to that, the president has the authority to receive ambassadors. That seems pretty innocuous, and at the time of the convention, it really was. At the time of the convention, the framers, operating against the backdrop of international law principles, decided that the president should receive ambassadors and foreign ministers from other countries as a way of fulfilling the nation's obligation under international law, which was to receive, a duty to receive ambassadors from other countries. That's how nations would communicate. So there was this duty imposed upon the president to do that. But it was not a discretionary opportunity. It was simply more efficient, as Hamilton explains in Federalist 69, for one person to meet and greet a foreign ambassador than it is to trot out, let us say, 535 members of Congress to stand on the steps of the Capitol and receive an ambassador from another nation. So again, the framers had in mind that the power to receive an ambassador through the reception clause, or what's often called the recognition power, would be a clerk-like administrative function devoid of discretion. But beginning with President Woodrow Wilson, presidents have utilized that non-discretionary clause in the most discretionary way to make and shape foreign policy, to decide if America will have foreign relations with other countries and what the tenor and tone of those relations will be. So what we see is a very clear theme, and we could spend a lot of time talking about this, of how presidents have aggrandized authority in foreign affairs to become the lead institution, in many ways relegating Congress to the sidelines in a way that's impervious to how the Constitution allocates powers to the two branches when it comes to foreign affairs. The president, of course, is expected to enforce the law. And that was the primary reason why the framers created the presidency, somebody who could administer the law in an efficient way. And that's, as I say, primarily what the framers were seeking through the invention of the presidency. And so this is a duty. This is a duty explained in Article 2 under the Take Care Clause, which is to say, the president shall take care to faithfully execute the laws of the land. This is a very important function. And the president has asserted over history broader authority, not grounded in the Constitution. So our students are familiar with the assertion of executive privilege, for example. Executive privilege is the claim by presidents that they have authority to withhold information from the public, but also from Congress. And this assertion of executive privilege is not grounded in the Constitution. It was asserted for the very first time in our history by President Eisenhower during the Cold War period, when he had his fill of the claims made by Senator Joe McCarthy of Wisconsin, after whom McCarthyism is named, was creating falsehoods about political allegiance and the behavior of people in the federal government. And when Joseph McCarthy requested names of people working in the Defense Department from President Eisenhower, Eisenhower refused because he thought McCarthy was a scoundrel. And when he refused to turn over information sought by Senator McCarthy, he invoked for the very first time in our history the words executive and privilege. They had not been previously conjoined until that point. And while the nation largely applauded Eisenhower for standing up to McCarthy after so many were crumbling in his presence, such was the intimidation of McCarthyism in our country, they applauded Eisenhower, but he essentially let the genie out of the bottle. And that has meant that ever since then, presidents have invoked executive privilege for a variety of reasons, hoping to maintain secrets or at least information within the executive branch that they did not want to release, largely to protect their political interest. And so the claim of executive privilege has loomed large in presidential politics and our legal history ever since. Probably Americans became more familiar with executive privilege than ever during President Nixon's time in office, during the Watergate period, and when the Congress investigating the Watergate crimes demanded information from President Nixon, including the so-called Watergate tapes, those tape conversations that he had with people coming into the Oval Office. The members of Congress on the Senate Select Committee, desiring those tapes to know what the president knew and when did he know it, as Senator Howard Baker famously said, Nixon refused to turn them over. He knew how damaging those tapes would be, and that led to a confrontation not only with Congress, but with the judiciary, because when a federal judge ruled against Nixon, rejected his claim of an absolute executive privilege, Nixon refused, and the judge ordered Nixon to turn over the tapes. Nixon refused. So here was a constitutional crisis of the greatest magnitude, a president refusing to obey a federal order. That rapidly led then to an appeal to the Supreme Court. And while the Supreme Court of the United States in a unanimous opinion, ruled against President Nixon, rejecting his claim of an absolute executive privilege to withhold information. The problem is that the court essentially created a presidential power by asserting that the president has a, quote, limited privilege. And that represented, I think, a dark moment in our constitutional history, because the court was essentially creating a presidential power out of whole cloth. And the president, and indeed Congress for that matter, lacks authority to create new constitutional powers for itself, just as it lacks authority to create new constitutional rights. The court doesn't have authority to do that. And so, as I say, the claim of executive privilege has allowed presidents of both parties, frankly, this is not a partisan issue, allowed presidents of both parties to place a lid on information that should be released, not only to Congress, but perhaps to the American people. And if you're wondering, well, what can we say about a governmental authority to withhold information from the American people? The framers granted that power to Congress in Article 1, Section 5, in which it provides Congress shall have the authority to decide what to publish in the daily congressional record. And so the framers had the opportunity to give to the president the authority of executive privilege, but they deigned not to. Instead, whatever authority, whatever information should be withheld from the American people for national security reasons, or whatever the basis of the claim, that belongs to Congress, not the president. But we've seen presidents abuse that. And it's one way in which the presidency has evolved into what we call the imperial presidency. What a fine term. That phrase was coined by a distinguished historian, Arthur Schlesinger Jr., in his prize-winning book called The Imperial Presidency, published in 1973, describing how over the course of American history, the presidency has evolved to more closely resemble the powers vested in a monarchy, far removed from the weaker office designed and created by the framers. So when we talk about the imperial presidency, we talk about the control of foreign affairs, war-making, national security, but it sneaks into domestic politics as well, through, in part, the assertion of executive privilege. Now, as the presidency has evolved and gained far greater power, to the point where leading scholars would say the framers would not recognize the presidency they created, we would also see presidents asserting immunity, claims of immunity, to say they could not be sued. We saw this, for example, during the Clinton administration, when Bill Clinton claimed that Paula Jones, who brought a lawsuit against him for sexual harassment at a time when he was governor of Arkansas, did not have the authority to sue him because he should be immune from lawsuits. Well, this was a sweeping claim, and the Supreme Court rejected it, holding that, in fact, presidents may be subject to lawsuits because if, frankly, a president is beyond the capacity of somebody to sue the president, and it's sharply limited, understand, then the president would be above the law. And remember how in our country we always talk about the fact that in America we're governed by the rule of law. What that phrase meant at the time of the founding was precisely that the executive was subject to the rule of law. So if we established a presidential immunity from suits, then the president would not be subject to the judicial process, and that would place the president above the law. Of course, the claim of presidential immunity has been carried even further since the Clinton administration. And of course, you may be familiar with the fact that President Trump claimed on numerous occasions that he couldn't be sued, that in fact, he could, as he famously said, in somewhat exaggerated terms, he could shoot somebody on Madison Avenue and he would not be arrested. He would not be in any trouble. Well, that was a function of his own philosophy, not only of presidential immunity, but a very broad prerogative power. And that leads us to say that some of President Trump's claims were grounded in precedent, but in other ways they were unprecedented. And when he claimed, of course, that he was not amenable to the judicial process, he was asserting the idea of presidential absolutism, which in and of itself would be a bizarre claim in our constitutional system, because we don't have any such thing resembling absolute power or absolute rights. But he was serious about it. And you may recall some speeches in which he said Article 2 grants the president absolute power, and on another occasion, unlimited power. No president, despite claims to broad authority over the course of our history, had ever come close to asserting such capacious powers. That would clearly place the president above the law. And in some ways, that proposition was made by an unfortunate memo in 1973 written by the Justice Department, specifically in the Office of Legal Counsel, saying that a sitting president may not be prosecuted. That was unfortunate because I think not only is it not law, it's just the opinion of a few lawyers, but people exalted it and said that in fact now that's policy and the president of the United States may not be subject to criminal prosecution. If you think about that, that essentially places the president above the law. And I would simply say that the framers of the Constitution were consumed with their efforts to limit the presidency, define the scope of power, and in no ways supported the idea that a president is beyond the reach of the judicial process. Along the way, in the course of 250 years roughly, we've seen all kinds of events that have led to further shaping of presidential power, all on the theme of increasing presidential power. And one of the claims, of course, has to do with the assertion of the exercise of the president's pardoning power. The president does have the authority to grant pardons, of course, to people for any offense committed against the United States. Committed against the United States means, of course, that the president's pardon power is limited to offenses that violate federal law. The president may not grant pardons for people who have violated state laws. That would be within the purview of the governor of an individual state. And historically, the presidential pardoning power has been exercised pretty judiciously. There have been some moments that shock the American people. The first probably would be when Gerald Ford, newly ascendant to the presidency in the wake of President Nixon's resignation, granted a pardon to President Nixon for the offenses that he may have committed against the United States. And to many people, critics, who believe that President Nixon should perhaps stand trial for the various crimes that he was alleged to have committed, that essentially removed from our system the knowledge that our system works. We lost that opportunity to see if a former president could in fact be subject to a criminal trial, and if convicted, would serve behind bars. That would be the acid test of determining whether or not our system really works and that we are committed as a system to the principle of the rule of law. That cost Jerry Ford considerably. In the 1976 election was very close. He lost narrowly to Jimmy Carter, and that probably explained why he lost. President Trump took it yet another step, as you know, when he asserted the authority to pardon himself, which no president had ever claimed, and that would in turn put the president above the law. I'm going to shift angles for a second because I see for some reason my laptop is powering down. So excuse me for about 3 seconds while I plug this in from another angle. You'll get to see another shot of my study, which isn't very clean. So I have to be really careful as to what I show. So excuse me just a second. I wouldn't want this to stop while we're talking. So we hope for a smooth transition here. I apologize for this. Maybe I need a new laptop. That could be it. Let's try this. Okay. All right. Can you see me a little bit? You might see more of me than you wish. At any rate, that claim by President Trump to authority to pardon himself is actually untested. It's an unprecedented assertion of authority, but because it's never been resolved in the courts, it's led some people to say, well, maybe the president could pardon himself, and others would say, no, it's absurd to assert that a president might be able to do that, again, because it would place that president above the law. Still having this technological ability problem, rather. I may end up having to just hold this. We'll see. All right, stay there. All right, there we go. We're going to live with this. So what we've seen in the evolution of the presidency from a scholarly standpoint is theories of presidential power that have more or less exalted the office in a way that far surpasses the expectations of the framers. And the question here is whether it's possible any longer to restore a constitutional presidency. The way we can address that, of course, in part, is to observe the way in which President Biden, our 46th president, asserts executive power. Will he, for example, build on the assertions made by President Trump? I don't think so. But will he simply carry forth the assertions by President Trump's predecessors, both Republicans and Democrats, which lay claim to broad authority in the realm of foreign affairs and national security? I expect he probably will. And if that's the case, then what we may say, is that in some ways, President Trump's assertions of authority represented an aberration, but other assertions of power by President Trump simply carried on the evolution of power exercised by the presidency over the course of American history. And so scholars will continue to assess this issue, will write about it, and will worry. How can we restore a constitutional presidency? Because if the president is behaving unconstitutionally, then we wonder how to control that president. And of course, the ultimate way to control a presidency is through the device created by the framers, which was the power of impeachment. But we saw during the Trump administration of how two instances of how a sitting president could be impeached by the House, but in both instances was not convicted by the Senate. And in the second Trump trial in the Senate, we saw a brand new claim whether or not the Senate could impeach a former president, because by the time President Trump went on trial, he was no longer president. So there's so much to talk about. I wish we could spend hours together exploring these, and maybe we'll have a chance another time. But I look at the clock, Tim, and I see that I probably talked too long already. And it looks like there's some questions I'd be happy to take, please.
Yeah, there's at least two or so that I've seen come through. Janet, do you want to ask one to begin with? I saw yours come through.
Oh, that microphone thing, right? Who's
Mhm.
ever done that? So I've been thinking about kind of, in addition to the presidency, analogous to states. And so we've seen several state legislatures, try to pull back on gubernatorial power. And in Indiana, our legislature has a supermajority of Republicans. We have a Republican governor. And our legislature did pass this session a bill which would severely restrict the governor's power in emergency situations such as COVID. And our governor has vetoed that bill because he feels it's unconstitutional due to a provision where it says in our state constitution that the governor has the authority to call a special session. But under the bill, the state legislature could call itself into session, if they deem the governor has exceeded his authority or her authority. So I was just wondering, like, how could we, kind of what your thoughts are on that. When I wrote the question, I told Tim it was poorly worded, but that's kind of like the gist of it and how that relates to executive power.
I think that's an excellent question. Thank you for raising that. The reality is that what your state is considering or has done is paralleled here in my state of Idaho and in other states across the country. And it goes right to that issue. How much power should the chief executive have, whether we're talking about the president or Congress, or excuse me, or state governor? That's always a question. That's a policy. It's a philosophical question. And what's occurred because of COVID, as you indicate, is that state legislatures across the country have become wary of the governors exercising too much authority to not only declare an emergency under their state constitution, which they have the authority to do because the Constitution says it's okay, but then deciding what regulations and limits to impose on businesses, for example, wearing masks, social distancing, and all the rest. You know how contentious these regulations have been. And then to the issue of whether or not the legislature should be able to trim the sails of the governor, so to speak, or in fact, to call itself into session. So the pandemic has created conditions in which people now are engaged in great discussions and debates about those kinds of questions. And isn't it interesting that in a lot of ways they mirror the debates during our founding period, how much power to give to the president? And there may be some differences between the federal level and the state when you consider that scope of authority. But the essential question remains: which officials should have the authority to declare an emergency? How broad should that emergency power be? And should there be any counterweight to it? Should the legislature be able to counter the executive? And when you think about the idea of limiting the executive's authority, you also then come to grips with, well, what if we are in an emergency? Do you want a single person making those important decisions? Or do you perhaps want a body of legislators acting in concert to undercut the governor's orders and regulations? And that can come with a lot of political freight. In our state, it was initiated by the hard right, but even some more moderate members of the legislature have jumped on board. So great philosophical questions to address. Fascinating. I'm glad you asked that. That's an important question for our time. Thank you.
Thanks. One other question that was dropped in the chat that I wanted to ask here for you too was, two tools in the executive's toolbox are using executive orders and signing statements. What do you think the founders would think of these tools that executives have been using?
Yeah, that's a very good question. That's on our minds and has been for years. The framers would not be concerned about executive orders because even during the founding period, President Washington and then Adams and Jefferson had to issue executive orders. The whole controversy about executive orders hinges on the scope of the authority asserted. So what we would understand is that the power of a president to issue an executive order is going to be part and parcel of a constitutional power, or part and parcel of authority granted to the president by the legislature. We don't have any problem, at least legally or constitutionally speaking, if the president stays within the confines of his authority, either his constitutional authority or the authority delegated by the legislature. Controversy arises, of course, when it appears that the president has exceeded his authority. And one of the historic examples, of course, occurred in 1952 in the famous steel seizure case, when President Truman, fearing that the economy would not function sufficiently to allow the steel companies to create enough steel to serve important projects, including the Marshall Plan in Europe when we rebuilt Europe, or to support our war effort in Korea at that time, issued an executive order to the Secretary of Commerce to order the steel companies he seized the steel companies to ensure that they would be open and producing steel in the face of a strike by steel workers. The Supreme Court then had a historic question before it. May the president essentially seize a private business? And the court ruled against the president, saying that contrary to President Truman's assertions, he did not have the authority to proclaim an emergency and to seize a business or an industry, actually. And so there was a claim where his order exceeded his authority. Another very controversial executive order was issued by President Roosevelt in 1942, when, of course, he was supported by a statute passed by Congress, essentially removed 125,000 Japanese American citizens from their homes in California, relocated them to camps in Western states. And why did President Roosevelt do that? He acted on the advice of a military report that was falsified on racist grounds, which said Japanese Americans are going to be disloyal. They will side with the Japanese Empire rather than the cause of America. And so he seized it. The Supreme Court, for a variety of reasons, upheld it, largely because the court was deferring to both the president and Congress. But historically, of course, it was proved to be a very shameful episode in American history. And ultimately, as you know, in 1988, Congress passed a statute providing compensation to those who had their homes ripped out from underneath them. So it's a shameful moment in American history. What it points out, if we were dealing with another topic, would be the question of just how deferential should the Supreme Court be to assertions of military necessity. Here, the court completely bowed because it said to itself, what if we overturn the president's order, prevent him from removing Japanese American citizens, and it turns out that the military report was right? Then we will have sold out America's national security. So that triggered a great debate about the degree of deference that the court should pay to the political branches. An ongoing debate, I might add. And on signing statements, quickly, there's not a problem with signing statements if all they represent is a presidential statement about how he will enforce the law in accordance with congressional intentions. When Congress passes a law and there's an issue arising about its meaning, Congress will often look to the legislative history, that is to say, the discussions and the debates by members of Congress as to what their purposes or their intent is for passing this law. The executive has the authority to enforce the law. So that in theory, there's no problem with a signing statement so long as the president is essentially signing this bill into law and explaining how, in his view, he will enforce the law as Congress intended. The controversy begins when a president essentially uses a signing statement to say something like, I'm going to sign this bill into law except for Section 4, let us say, because I think that Congress has acted unconstitutionally or unwisely, and I will not enforce that. That is a way for a president who doesn't like a bill to have his cake and eat it too. The proper way for a president to treat a bill which finds repugnant or unconstitutional is to veto it, return it to Congress with his objections, and then giving Congress a chance to cure the objections, write a better bill, or perhaps to override a presidential veto. But when a president signs a bill into law and says, I'm not going to enforce particular sections, that's essentially vetoing the bill without exercising the veto authority. That's when presidents have usurped the lawmaking power assigned to Congress. Those are great questions. Thank you.
Wonderful. Well, as I'm looking at the clock, it looks like we're really approaching the top of the hour here too. And so to me, that went very fast, and it was very wonderful to listen to you and all that. It was great insight. So
Well, thank you, Tim.
Yeah,
you.
absolutely. I mean, our thanks to you very much, Dr. Adler. I mean, wonderful presentation, lots of good information. Thanks for teaching us the content so we can turn around and teach our students more about the content as well. So thanks for sharing your time and your scholarship. I enjoyed listening to it. I'm sure the fellow educators did as well. So thank you.
Well, I appreciate the invitation. It's nice to join you again, and I see some faces on the screen. Thanks for sticking with me. If, by the way, you have any questions, Tim, feel free to share my email.